The screen on my badge reader flashed red at 2:47 on a Tuesday afternoon, and I remember thinking, that's fast. My daughter-in-law hadn't even made it back to her office yet. I'd watched her walk out of the conference room 17 seconds before it happened. Heels clicking down the hallway, not even looking back. The kind of exit you practice. I stood there for a moment, holding my badge against the reader like maybe it was a glitch. 41 years of muscle memory telling my hand to try again. The little light blinked red a second time, then a third. Marcus from IT was sitting at the front desk. He'd watched the whole thing. He looked down at his keyboard the moment I turned around. I didn't say anything. I set the badge on the counter, picked up my jacket from the chair by the window. The chair I'd sat in every morning for 11 years waiting for the elevator, and I walked out to the parking lot. It was 62 degrees. A Tuesday in October in Austin, Texas. The sky was doing that thing it does in fall where it's too blue, almost offensive about it. I sat in my truck for a while without starting the engine. My phone buzzed. My son. I let it go to voicemail. I'd known this was coming. Not in a vague, uncomfortable way. I mean, I knew it specifically. I'd watched my daughter-in-law, the company's new chief innovation officer, spend 6 months methodically removing every technical lead who'd been there before her. First, it was the VP of architecture. Then the 2 senior engineers who'd built the original data pipeline. Then my old deputy, who'd worked with me since the Delaware days. All of them gone by August, all replaced with people she'd brought from her previous company. People who called meetings to discuss leveraging our innovation ecosystem and scheduled 45-minute syncs to align on alignment. I was the last one. I understood why I'd taken longest. My name was on the original filing. Not metaphorically, literally on the patent documentation. United States Patent 10,847-291, filed in 2013. My algorithm, my architecture, my 72 consecutive hours without sleep in a server room in Round Rock. The entire product that the company had been built on, that had landed them a $340 million government contract with the Department of Defense, that had made their upcoming IPO possible at a projected valuation of $2.3 billion. All of it ran on a foundation I'd designed from scratch. My daughter-in-law knew that, which is why she'd spent the last 3 months trying to get me to sign a document she kept calling a contribution acknowledgement agreement. I hadn't signed it. She'd framed it 6 different ways. First, it was administrative. Then it was standard procedure before an IPO. Then she had one of her lawyers call it a routine IP consolidation form. The last time she'd brought it up, 2 weeks before that Tuesday, she'd sat across from me in my own office and said with complete seriousness that I needed to think about my legacy within the organization. I asked her if she'd read Section 12 of my original licensing agreement, the one from 2013, the one that her father-in-law, my son, had countersigned when the company was 18 months old and running out of runway. She told me that document was outdated. I said okay. I didn't say anything else. She left. I called my IP attorney in Dallas, a woman named Carol who I'd worked with since 2008. I told her what was happening. She asked me 2 questions. I answered both of them. She was quiet for a moment, and then she said, "Don't sign anything. And Marcus, document everything from here forward." I did. The board meeting where it finally happened wasn't about me. That was almost funny. They'd scheduled it to finalize the IPO timeline. Roadshow dates, underwriting terms, the whole apparatus of a company about to go public on the NASDAQ. My daughter-in-law had put me on the agenda as the 3rd item. Personnel update. 11 years of building the thing that made all of it possible. Reduced to a 15-minute agenda item between Q4 projections and catering vendor for the IPO celebration. She stood up and explained that the company was transitioning to a next-generation technical leadership model. She used the word scalable 4 times. She said my role had evolved beyond its original scope and that the organization needed to right-size its foundational team ahead of the public offering. The board members, most of whom my son had brought in during the Series B round, people who understood cap tables better than code bases, nodded along like she was describing a weather pattern. My son didn't look at me once during the entire presentation. When she finished, the board chair asked if there were any questions. There weren't. My daughter-in-law looked at me across the table with the specific expression of someone who has rehearsed this moment and found it going according to plan. I asked one question. I said, "Have any of you read Section 12 of the original licensing agreement, specifically the reversion clause in paragraph 4? The room was quiet for about 3 seconds. My daughter-in-law smiled, the kind of smile that's actually just showing teeth, and said that the legal team had reviewed all foundational agreements as part of IPO due diligence and everything was in order. I said, okay. I picked up my notebook, the same moleskin I'd carried to every meeting for 11 years, and I stood up. I said, enjoy the roadshow. The next few weeks are going to be very interesting. I walked out. 41 seconds later, my badge stopped working. What my daughter-in-law's legal team had apparently not read carefully enough, or had read and decided was a problem for future them, was paragraph 4 of Section 12. My original agreement wasn't an employment contract. That was the part everyone seemed to forget, or had never fully understood. When my son had come to me in 2012 with nothing but a business plan and $70,000 of seed money, I hadn't joined his company as an employee. I'd licensed my existing patent portfolio to the company in exchange for equity, a seat on the technical advisory board, and this was Carol's language from back in 2013, and I'd insisted on every word of it, a reversion clause. The clause stated, in language that Carol had made deliberately unambiguous, that if my advisory role was terminated without cause prior to the company's 5th year of profitability, or if the company materially misrepresented my contributions to the licensed technology in any public filing, the license reverted to me automatically, not to my estate, not subject to arbitration, to me, immediately, with 60 days notice to cure. The company had been profitable for 4 consecutive years. They were 3 months from their 5th anniversary of profitability, and 3 weeks prior, their S-1 filing with the SEC had described the core algorithm, my algorithm, as developed internally by the company's founding technical team. I was not listed as part of the founding technical team. Carol had flagged the S-1 language the day it was filed. She'd sent me a 3-paragraph email with no subject line, which was her way of telling me something was serious. I'd read it twice, set my phone face down on my kitchen counter, and gone for a run, 6 miles through my neighborhood in Cedar Park, past the same streets I'd driven every morning for a decade, trying to figure out how I felt about what was about to happen. By the time I got back, I knew. I called Carol. I told her to prepare the notice. She asked if I was sure. I said yes. She filed it that afternoon. Certified mail to the company's registered agent, email to their legal team, and, because the licensing agreement required it, a copy to the USPTO. The notice gave them 60 days to cure the deficiency in the S-1, specifically by amending the filing to accurately attribute the patent's inventorship. The 60-day clock started running on a Monday. They fired me the following Tuesday. I want to be honest about what the next 2 weeks felt like, because it wasn't triumphant. I'd like to tell you I spent those days calmly executing my plan, feeling confident and righteous. That's not what happened. What happened was, I sat in my house in Cedar Park and felt genuinely terrible. My son hadn't called me back, not after the board meeting, not after the filing, not when Carol's notice arrived at the company's registered agent and presumably landed on someone's desk like a grenade. Silence. Complete, total silence from a person I'd taught to drive a stick shift in a parking lot in Plano when he was 16 years old. I'd built something that mattered. I'd built it because he'd asked me to, because he was my kid and he needed help and I had something to offer. And somewhere in the years between that server room in Round Rock and that board meeting, he'd let someone convince him that the thing I'd built was an inconvenience. That part was harder than the patent. The patent was just a document. The other thing was something I couldn't put in a filing. I cooked a lot. I watched football. I called my sister in Amarillo and didn't tell her what was happening because she would have driven 6 hours to be furious on my behalf, and I didn't have the energy to manage that. I called my old deputy, the one my daughter-in-law had let go in August, and he came over on a Saturday and we sat on my back porch and drank coffee, and he said, "How are you actually doing?" And I said, "I don't know yet." He said that was a fair answer. Carol called every few days with updates. The company's legal team had responded to the notice. They were contesting it. They'd retained a patent litigation firm out of New York, one of the expensive ones, and their position was that my licensing agreement was superseded by implied terms created through my years of employment. Carol explained, with the patience of someone who has had this conversation many times, that implied terms was not a legal standard that applied to a written licensing agreement with an explicit reversion clause. She said she'd responded to that effect. She said to sit tight. The IPO roadshow was scheduled to begin on a Wednesday 5 weeks after my badge had stopped working. I knew the date because the financial press had been covering the company for months. The valuation projections, the lockup period terms, the institutional investors who'd already indicated interest. The company was a good story. Defense tech, government contracts, proven revenue, the kind of IPO that gets covered on the front page of the journal. The Monday before the roadshow at 6 a.m., I got a call from a number I didn't recognize. Area code 2C2. I answered it. The man on the other end identified himself as an investigator with the Defense Contract Audit Agency. He said he'd like to ask me some questions about the algorithm underlying the company's Department of Defense contract. He said he was asking because they'd received documentation suggesting there might be a discrepancy in how the technology's ownership had been represented in the original contract filing. I said I'd be happy to answer any questions he had. We talked for 90 minutes. I won't go through all of it. Some of it is still not mine to discuss publicly, and some of it is just procedurally tedious in the way that government investigations always are. What I can tell you is this. The Department of Defense contract had been awarded in part because the company had represented in its contractor certification that the core technology was wholly owned by the company, free of any third-party licensing arrangements or encumbrances. That representation had been made 3 years prior, during the contract negotiation period. At the time that representation was made, my licensing agreement, with its reversion clause, was very much an active third-party licensing arrangement. The DCAA investigator did not tell me what the implications of that were. He didn't have to. I'd spent 11 years working adjacent to government contracting. I knew. Carol called me that afternoon. She'd been contacted as well. She said, "Marcus, I need you to understand that this has moved significantly beyond a civil licensing dispute." I said I understood. She said, "How do you feel about that?" I thought about it. I said, I built that system to do something that mattered. The DoD contract mattered. The people using that system in the field, it mattered to them. I don't like that I'm here, but I'm not going to pretend the misrepresentation wasn't serious. She was quiet for a moment. Then she said, "Okay. Then let's make sure your documentation is airtight." It was. I've been keeping records since 2012. The roadshow was postponed. I found out from a Wall Street Journal alert on my phone, same as everyone else. Austin-based defense tech firm delays IPO amid undisclosed regulatory inquiry. The stock exchanges don't love uncertainty, and institutional investors like it even less. 3 of the 4 anchor investors had already signaled they were stepping back pending clarification. My son called me that evening. First time since before the board meeting. He didn't say hello. He said, "Dad, what did you do?" It wasn't really a question. I said, "I protected something I built. The same way you would have if someone had tried to take it from you." He was quiet, long enough that I thought he might have hung up. Then he said, "She said you'd do something like this. She said you were never going to just let it go." I said, "She was right. She just didn't account for the DoD part." More silence. I said, "I'm not trying to destroy the company. I never was. But you let her file an S1 that said I didn't exist. You sat in that room and you didn't say a word." He said, "It's complicated." I said, "It was a checkbox on a form, my name. That was all I was asking for. I heard him exhale, something between a breath and something else. I said, I love you. That hasn't changed. But I spent 11 years building something real, and I'm not going to pretend I didn't. He hung up. I sat with the phone in my hand for a while. The October dark was coming in through the kitchen window. I thought about that server room in Round Rock. I thought about the first time the system had processed a live government dataset and returned results in 0.3 seconds, and my son had grabbed my shoulder and said, Dad, I think we actually did it. I thought about all the nights between that moment and this one. Then I put the phone down and went to bed. The cure period expired 31 days after the IPO was postponed. The company had not amended their S-1. They'd filed a motion in federal district court in Austin seeking an injunction against the reversion, their legal theory being that the reversion clause represented an unreasonable restraint on alienability of intellectual property. Carol had filed a response in 48 hours. The judge denied the injunction request in 6 days. The written order was 4 pages. It cited 3 precedents. It was not close. The license reverted to me on a Thursday morning. Carol sent me a copy of the USPTO acknowledgement with a 2-word email. It's done. I read it 3 times, printed it out, held the paper in my hand. My algorithm, my architecture. The thing I'd built in 72 sleepless hours in a server room in Round Rock was mine again. Legally and without ambiguity, as of 9:14 a.m. on a Thursday in November. What happened next moved faster than I expected. The DoD contract was placed under review, standard procedure when the IP basis of a defense contract is disputed. That review suspended the company's billing under the contract pending resolution. For a company whose revenue was roughly 70% DoD arrived, that was existential. Their line of credit, which was collateralized in part against the contract, triggered a covenant default. The bank sent a notice of default within the week. I didn't know all of this in real time. I learned most of it afterward, from Carol and from the press coverage and, eventually, from my son. What I knew in real time was that my daughter-in-law called my personal cell phone on a Saturday morning, 11 days after the reversion. I hadn't heard her voice since the board meeting. She said, I'd like to meet, just to talk. I said, okay, coffee. Monday morning, Epoch Coffee on North Loop, 8 o'clock. She said, can we do somewhere more private? I said, no. Monday, 8 o'clock, North Loop. She was there when I arrived. I'd expected her to look angry or strategic. She usually looked strategic. She looked tired. The specific kind of tired that comes from several weeks of things not going the way you planned them. I ordered my coffee. I sat down across from her. She said, we want to negotiate a new licensing arrangement. I said, I know. She said, the company can't function without the algorithm. The DoD contract is the company. I said, I know. She said, so what do you want? I'd thought about this for a long time. Longer than she probably assumed, because what I wanted wasn't complicated, and it wasn't punitive, and it had nothing to do with making her suffer, even though there were moments in October when I would have answered that question very differently. What I wanted was what had been mine from the beginning. I said, I want my name on the patent as the sole inventor, corrected in every filing where it was misrepresented. I want a revised licensing agreement with my company. Not with me personally, with an LLC I've established, at a royalty rate that reflects fair market value for foundational defense technology. I want a formal written acknowledgement, signed by the board, that my contributions were misrepresented in the S-1. And I want my son's direct equity stake in the company to be unaffected by whatever restructuring comes next. She looked at me for a long moment. She said, that's it? I said, that's it. She said, you could ask for more. I said, I know. She said, why aren't you? I said, because I built that system to do something that mattered. I still want it to matter. I just want it to be mine while it does. She looked out the window for a moment. Austin traffic going past on North Loop. The ordinary morning of a city that didn't know or care about any of this. Then she said, I'll take it to the board. I said, Monday. I'll need an answer by Friday. The board approved the terms on Thursday. The corrected patent filing was submitted to the USPTO before the end of the month. The licensing agreement, negotiated between Carol and the company's new outside counsel, my daughter-in-law's New York firm had quietly disengaged, was executed 6 weeks later. The royalty rate was 4.2% of gross DoD contract revenue, which worked out in year 1 to a number that I won't put in writing, but that made Carol pause for a full 3 seconds when she read it. The company's IPO was relaunched in February with an amended S-1 that listed my name correctly. The offering priced at the low end of the range. It wasn't the triumphant bell-ringing moment my daughter-in-law had choreographed in her head. But it happened. The company survived. My son called me the night after the IPO closed. He said, I should have said something. In that room, I should have said something. I said, yeah. He said, she's not a bad person. She just wanted the company to succeed. I said, I know. I wanted the same thing. He said, I'm sorry, Dad. I said, I know that too. We talked for a while after that. Not about the company, not about the patent or the DoD or any of it. He told me his youngest had started walking. I told him about a hiking trail I'd found outside of Marble Falls. Good one for the fall. The ordinary conversation of people who have come through something and are finding their way back to who they were before it. We didn't fix everything on that phone call. Some things take longer. But we talked, and that was enough for that night. I get asked sometimes, by friends, by the other technical people I know who are watching their own versions of this happen in their own companies, what I would have done differently. Whether I'd have structured things differently from the start, protected myself better, drawn harder lines earlier. I think about it. The honest answer is, not much. And not in the ways people expect. I would have made sure the S-1 attribution clause was airtight in the original agreement, rather than relying on the misrepresentation trigger. That's a Carol-level technicality that could have resolved everything in weeks instead of months. But the larger answer is no. I wouldn't have done it differently. I built something because my son needed help, and because the problem was interesting, and because I wanted to do something that mattered. I licensed it instead of selling it because I believed in the reversion clause, not as a weapon, but as a record. A statement that I had been here, that the thing was real, and it was mine, and the record would reflect that whether anyone wanted it to or not. The Patent Office sent a formal letter of commendation in December, something related to the DoD contracts application in a program I'm not at liberty to name specifically. The letter was addressed to me, my name. Correct. And first, and unambiguous, I have it framed in my office now. Not because I need the validation. I know what I built, I've always known. But because sometimes you need a document to say the thing out loud that the room was too quiet to say when it mattered. I built that system. It worked. And in the end, the record says so. That's all I ever wanted. I've thought a lot about what actually caused all of this. Not the legal mechanics, not the clause or the filing or the DCAA call. The deeper cause. The thing underneath. What I keep coming back to is this. Diane didn't steal from me because she was evil. She did it because she'd spent her entire career in rooms where the person who could talk about a thing most confidently was treated as the person who owned it. She'd learned that narrative was property. That if you controlled the story, the S-1, the press release, the org chart, you controlled the asset. And for a long time, in a lot of rooms, she wasn't wrong. What she didn't account for was that I'd spent 40 years doing the actual work, not talking about it, doing it. And there's a difference between those two things that no amount of confidence can paper over when a federal investigator starts asking specific technical questions at 6 in the morning. I think about integrity a lot differently now than I did when I was younger. When I was 30, I thought integrity meant being honest when it was hard, telling the truth in uncomfortable moments. That's part of it. But what I understand now, what this whole experience clarified for me in a way nothing else could, is that integrity is also structural. It's the work you do before the crisis. It's the licensing agreement you insist on in 2013. When the company has no money and your son is grateful, and it would be so much easier to just shake hands and trust the relationship. It's the records you keep not because you expect to need them, but because you respect the work enough to document it properly. Carol didn't save me. My own habits did. Carol just knew how to use them. And then there's the matter of holding on, not bitterness. I want to be precise about that distinction, because they can look similar from the outside. Bitterness is wanting the other person to suffer. What I had was something quieter and more patient than that. It was the refusal to let the record be wrong. Those are different things. One of them eats you alive. The other one is what gets you to the finish line. My son asked me once, after everything had settled, whether I'd been angry. I told him the truth. Yes, but not at Diane. At the silence. The 11 seconds between when my badge stopped working and when Marcus at the front desk looked down at his keyboard. That's silence. The institutional kind. The kind where people see something wrong and calculate whether it's safe to acknowledge it. That was the thing that hurt. The individual betrayal I could metabolize. The collective one took longer. What I tell anyone watching this is something I wish someone had told me at 40. The thing you build is not separate from you. It carries your fingerprints at the molecular level, and no filing can fully remove them, which means protecting it isn't vanity, it's stewardship. You owe it to the work to make sure the record is accurate, not for your ego. For the next person who comes along and needs to know that honest, careful, persistent effort actually leads somewhere real, it does. I have the framed letter to prove it, and my son and I talked last Sunday. His youngest took 6 steps across the kitchen floor without holding on to anything. Some things repair themselves if you give them enough room.